he also told Mr. Thompson to turn the music back up. And so it was Mr. Davis that first went into a rage. Now, Mr. Brunson and Mr. Thompson then say they did not hear because of the volume of the music. They did not hear what specifically was said to Mr. Dunn that finally got Mr. Dunn's attention, because to that point they verify that Mr. Dunn sat quietly, he did not react, and that the fact that he did not react to Mr. Davis yelling at him actually made Mr. Davis angrier. And they had seen him, or I should say Mr. Brunson had seen him become angry and enraged before. But he did finally say something that got Mr. Dunn's attention, and Mr. Brunson and Thompson didn't hear what that was. Now, Mr. Dunn's unrebutted testimony that the state did not rebut at all was that this was, of course, a death threat, words to the effect of, "I'm going to kill you." Mr. Brunson and Mr. Thompson did hear Mr. Dunn say, "Do you mean me?" or words to that effect, "Are you talking to me?"
Well, counsel, doesn't that kind of suggest if the other individuals in the car heard your client say, "Are you talking to me?" but didn't hear the victim in this case say, "I'm going to kill you"? Isn't that inconsistent with the hypothesis that in fact he did threaten him? In other words, they didn't hear it because he didn't say it.
No, they weren't able to say he didn't say it. That would be inconsistent. This was neutral. He said something outrageous.
Isn't there an inference that the fact that they heard what Mr. Dunn said but didn't hear what Mr. Davis said, that he didn't say it?
Well, no.
Can't that be inferred?
We know the only thing possible to infer is that after cursing and saying pretty volatile things, that Mr. Davis finally said something that forced Mr. Davis or prompted Mr. Davis to say, do you mean me? Are you saying that to me? And what Mr. Brunson and Mr. Thompson said, testify is, they both agree. He said, "Yes, I mean you." So he definitely said something that was beyond the pale. Now we have only Mr. Dunn's word.
The fact that I believe that there doesn't seem to be a lot of debate as to what Mr. Dunn said. And I believe the exact words, as I recall it, were, "Are you talking to me?"
Right.
Now, to me, that doesn't sound like somebody who's particularly frightened. That sounds to me like somebody who's being somewhat confrontational. If I'm right, and I'm just making a suggestion, wouldn't that be an inference?
Well, his unrebutted testimony was that, no, at first he thought that they must have been talking about something else, that he was in a bit of disbelief, that he thought that the rage was out of proportion with what everyone agreed was a polite request to turn the music down. And he didn't ask again once the music turned back on. He didn't turn around and say, "I said turn that down," or anything like that. Didn't exit the vehicle, didn't address Mr. Davis in any way. So, I mean, the standard here is that if the evidence leaves room for two or more inferences of fact, at least one of which is consistent with the defendant's hypothesis of innocence, it's not legally sufficient to make a case for the jury. So the standard isn't that the state can come up with some inference or a hypothesis of guilt. It's that they have to rebut the hypothesis of innocence.
So as long as there's two different possibilities, then a judgment of acquittal must be granted?
One of which that results in innocence and is not rebutted by any of the state's evidence.
Well, didn't Mr. Smith, though, patron at the gas station, testify he didn't see any weapons in the Durango, and therefore that rebuts Mr. Dunn's claim that there was the barrel of a shotgun sticking up? It
does, but it doesn't rebut his claim of innocence. What the operative facts here are is that once he says, "Yes, I mean you," that Mr. Brunson, who was the only person in the back seat with Mr. Davis, says that Jordan Davis is now trying to get out of the vehicle. Now, he says he was prevented by child locks, that all of the other state's witnesses, including Mr. Storns and Mr. Thompson, who had spent substantial amount of time in the vehicle, they said these child locks affected the windows but not the doors. However, even accepting Mr. Brunson's testimony that Mr. Davis was just attempting to get out of the car and saying, that this argument is escalating, that his screaming is escalating, and trying to get out, is absolutely consistent with the hypothesis that Mr. Davis was sort of coming for Mr. Dunn. I think if someone came to your house in the middle of the night, was trying to open the door, but the door was locked, that you would be in a reasonable fear. And so that's the case here. However,
trying to open the door, Mr. Davis never touched Mr. Dunn's door. You're saying trying to open the door to get out of the
Trying to open his own door to get out.
That's a big difference, it seems.
Now the only accident reconstruction expert who testified in both trials said the door was definitely partway open and that Mr. Davis was definitely partway out, partway in the vehicle when the shots occurred.
Mr. Roberts, one thing that I keep going back to what you said the standard was with regard to consistency of the evidence, and I'm having trouble seeing how the state could ever have disproved his self-defense claim if as long as the evidence is inconsistent, then the court was required to grant a judgment of acquittal. How could the state have possibly met that standard?
If Mr. Brunson had ever said, he never said that, that would rebut it. He never threatened him.
But why can't there be an inference that he never threatened him based on the fact that they didn't hear a threat?
Well, an inference isn't substantial evidence. That's mere suspicion. I mean, there has to be
Don't we consider
evidence.
all reasonable inferences in deciding on a judgment of acquittal?
All reasonable inferences from facts. But all that Mr. Brunson and Mr. Thompson give you here is they didn't hear whatever outrageous thing Mr. Davis said that prompted.
Back to a motion for judgment of acquittal. Do you agree that a judgment of acquittal should be denied unless no reasonable interpretation of the evidence could support a jury's finding of guilt?
Yes, absolutely. But Mr. Brunson and Thompson candidly admitted they didn't hear what outrageous thing it was that prompted that comment of, do you mean me? Yes, I mean you.
Let's get back to the firearm. Even if Mr. Davis said, I'm going to kill you to Mr. Dunn, if he doesn't have the means to do so, Mr. Dunn can't use deadly force against him.
Well, that's not exactly correct, Your Honor.
So if you said, Judge, I'm going to kill you, I could just blow you away right there. I don't think that's the law.
No, the belief had to be reasonable, that the threat need not have been actual. That's language from the jury instructions.
But it's got to be, he's got to have a reasonable belief that Mr. Davis is coming after him and going to use force against him such that Mr. Dunn could return with deadly force.
Well, a death threat in combination with, he thought he saw a firearm in Mr. Dunn's hand. That's the testimony. Now, Mr. Brunson's testimony, which we have to take as true, is that what he was holding was a cell phone. He had a Smith & Wesson pocket knife in his his pocket, but we have to take Mr. Brunson's word that what was in his hand at that moment was a cell phone that he was holding against.
So the reasonableness of Mr. Dunn's belief or the lack thereof, doesn't that create a jury question that the JOA was properly denied?
Well, no. If the jury instruction is that if the belief, it's an objective test that's reviewed de novo here, and if Mr. Dunn, he's looking back behind him to his left, sees something in the hand, and hears a death threat, and then hears the door start to open, that created a reasonable fear, and that the state failed to rebut that with anything.
Counsel, do you agree that there were conflicts in the testimony of Mr. Dunn as opposed to Mr. Smith's testimony, a patron at the gas station? Were there conflicts in the testimony of Mr. Dunn compared to Mr. Smith, a patron at the gas station?
I don't think there were substantial conflicts.
Was there a conflict between Mr. Dunn's testimony and Mr. Atkins, another patron at the gas station?
The which, I'm sorry?
Mr. Atkins, another patron at the gas station.
I don't think there were substantial conflicts. And I think that we are, and Mr. Brunson and Mr. Thompson verified all of this.
Mr. Dunn's testimony and the passengers in the Durango.
No, they absolutely said they couldn't hear what outrageous comment it was, but that Mr. Dunn had been polite and then said, do you mean me? And then Mr. Davis said, yes, I mean you.
With regard to any conflict in testimony, why wasn't it in the jury's duty to determine whether the evidence presented could exclude appellant's theory of self-defense?
Well, this case is just like Diaz, where you have a man in a restaurant approached by someone, no one hears the death threat, but Mr. Diaz says, he told me he was going to kill me. I pulled out a gun, he fired. It turned out that patron who allegedly threatened Mr. Diaz didn't have a gun. He was mistaken about being under imminent threat of death, and the Diaz case reversed, saying, look, we've got a death threat here. No one can say any different. And that's what it comes down to, is we've got a death threat here. We've got verified rage. We've got verified attempt to exit the vehicle. We've got a verified something in Mr. Davis's hand. And we've got no one saying any different. So we're left with, at the best, mere suspicion. we can maybe think that something else happened. But did the state come and say there wasn't a death threat? No, they said we didn't hear what was said. That's the standard. There has to be someone saying he never said that. He didn't do that. That's what they have to show. And in this case, they can't. There's a death threat that's unrebutted. It wasn't verified by anyone else, but it was unrebutted. And that's the key here. They have to have someone say that didn't happen, or they have to show some sort of evidence that said that couldn't have happened. That didn't happen. But Mr. Davis's friends admit that he was the one in a rage, that he was the one that was angry, that Mr. Dunn was passive, right up until Mr. Davis tries to get out of the car, and then Mr. Dunn goes for the weapon. And of course, there was the shooting. I see that I'm into my rebuttal time, so I will reserve the rest unless there's immediate questions.
Counsel, if you are questioning, we will extend your rebuttal time by an additional 2 minutes. We'll extend the state's argument by an additional 2 minutes as well.
Okay, thank you, Your Honor.
Good morning. May it please the court. My name is Matthew Pavis. I represent the state of Florida. Judge Bilbrey, I think you're hitting the nail on the head that there was no evidence that there was evidence inconsistent with appellant's claim that there was a shotgun. What it seems like appellant's doing on the JOA argument is piecemealing the specific self-defense claim that defendant raised below. What he said below was that Jordan, armed with a shotgun, was getting out of the car threatening to kill me. That is the entire self-defense claim. We don't need to piecemeal out which ones we actually rebutted versus which ones we didn't. Now, I see this regardless as three different elements to his own self-defense claim that we could try to present inconsistent testimony to. The shotgun, the threat, and whether or not the door opened. I don't think anybody's disputed that all of the passengers in the car said there were no firearms in the car, and that even when they left the Gate gas station, nobody disposed of any firearms within that time period before returning, which right there is evidence inconsistent with the fact that Jordan had a shotgun. And that is sufficient to put the remainder of the self-defense reasonableness to the jury. But also, as it speaks to the threats, Judge Winokur, you kind of hit the nail on the head with this. Leland, who's sitting in the back seat and observing this whole thing from behind Jordan's back and through to appellant's car, said, I can hear what the defendant is saying, but I didn't hear any threats made by Jordan in this case. And it's circumstantial evidence, and that evidence, which was circumstantial in nature, was evidence inconsistent with Dunn's self-defense, that there was a threat. So although...
Well, can you address appellant's claim then that obviously the fact that they heard nothing is inconsistent with the testimony, well, let me rephrase that, is not inconsistent with the testimony that he did in fact say it, which the only testimony was Mr. Dunn's, that he in fact made a threat, and there was nothing inconsistent with that.
It was circumstantially inconsistent because it seems apparent that Leland would have heard this threat based on his position observing the entire incident. Also, though, when we get to this Diaz case, where we have this shooting that occurred in a restaurant that the patrons did not see. But in Diaz, what the court said was, and the incident per se was observed neither by the owner nor the employees nor any of the other patrons. So in Diaz, what it was that nobody observed it. Even though everybody was sitting in that restaurant, nobody saw the self-defense claim. And there, the defendant's self-defense claim was that he twice threatened him, then rose, approached, again making threats, reaching into his pocket. Here, the entire incident about what was going on between Jordan and the defendant was observed, at the very least, by Leland, who was sitting in the backseat watching this entire incident. He can testify that he had a cell phone in his hand, that he was trying to get out even though he couldn't get out. He could hear what the defendant was saying. This isn't a situation where he wasn't paying attention to what was going on. He was an active participant in what was going on. So the weight of that circumstantial evidence and that inconsistency is certainly greater in this case than it was in Diaz. And Judge Lewis, you hit the nail on the head with this too. Witness Smith and Atkins, who were in the parking lot, gave testimony which was inconsistent on its own and based on their independent observations with appellant's self-defense claim. Witness Smith said he didn't see a shotgun, he didn't see any weapon, he didn't see the door open, and he testified specifically, and this is on volume 17, 1339 of the first trial, you're not going to talk to me that way. And that was Witness Smith's that testimony really keys into the fact that he wasn't afraid for his life prior to shooting. This shows that he was acting vindictively prior to the shooting. So when we look at the entirety of appellant's self-defense claim, it really was specifically that armed with a shotgun, Jordan was threatening to kill him and trying to get out of the car. And the state presented evidence inconsistent with that theory. And when we look at the Rivera case, which was the other case that's been heavily cited by both parties, Rivera is the road rage case where the defendant was being chased by a car of people, things are getting thrown at him, they're trying to run him off the road, they pull off the highway, the victim gets out of the car, and the defendant shoots the victim. In that case, the appellate court rejected the fact that the state presented evidence inconsistent, because there the state only rebutted the fact that that the victim was armed with a firearm when he approached the car. But the court was able to say, well, you didn't rebut the fact of this vicious road rage chase that gave the defendant a reasonable self-defense claim. We know for a fact that that happened. Here, the one incident, the sole incident, was that Jordan was armed with a firearm, a shotgun specifically, and that he was going to get out of the car to kill appellant. We don't piecemeal that apart on appeal because the state presented evidence inconsistent with that theory. Touching briefly on the fact that it was actually a cell phone it may have actually been a cell phone in the hand per Leland's testimony. Again, this goes back to appellant's specific self-defense claim. He testified extensively that he knew that was a shotgun. On appeal, we don't get to say, well, maybe he was mistaken in that belief, because what the state was doing below and what the argument below was that they needed to rebut that he was holding a shotgun, because the point of appellant's and the thrust of appellant's self-defense claim was that I was in fear for my life because he had a shotgun, was threatening me, and was getting out of the car. It wasn't that I thought he might have had a shotgun. The state didn't need to present evidence inconsistent that he was holding nothing in his hand, although witnesses Smith's testimony would have been inconsistent anyways because he said he didn't see him holding a gun in his hand. We only needed to present evidence inconsistent with appellant's specific theory of defense. And that specific theory of defense was that armed with a shotgun, he was being threatened to kill, and that Jordan
Well, he doesn't, but again, he doesn't have to demonstrate that Mr. Davis actually had a shotgun. No shotgun, no self-defense. That's clearly not the law. The law is what Mr. Dunn reasonably believed.
Yes, but in this case, under the facts, what his reasonable belief, what he was asserting was his reasonable belief, was that he did have a shotgun. So the state was right to merely rebut that presumption. After testimony of Mr. Dunn, we know for a fact that he thought he had extensive experience with shotguns. He testified in several pages about going skeet shooting and understanding what a shotgun looked like. He said he saw a barrel of a shotgun. And so it would be unfair on appeal to then say the state, had to rebut that it was anything in Jordan's hand. Really what the state was focused on was his specific self-defense claim. And that specific self-defense claim regarded a shotgun. And that was rebutted.
Can I jump ahead to issue 4
Yeah.
and Dr. Simmons' testimony and the appellate's claim that it was outside her area of expertise? Would you like to address that? Because that's an issue that I have some concerns about.
Yes, Your Honor. I think the best way to begin addressing this issue, too, is to just re-look back at the initial motion in limine. Now, factually, this occurred between the first and the second trial, and the defendant sought a motion in limine to prevent the medical examiner from testifying as to the position of Jordan's body and the position of the door during the second trial, which was going to be the next trial. And the trial court's order really guides us in this. And what the trial court was relying on in this was the deposition presented during the motion in limine of the medical examiner and how she was going to be able to give this opinion. And there, the trial court, when it found that she was qualified, which is what they're really objecting to on appeal, that she didn't have the qualifications to testify this way. What the trial court relied on, and this is on page 1235 of the record, was 15 to 20 shootings that she had been out to. She had observed and held rulers. She had 2 courses in training on how to use dowels. She had taken courses in forensic scene photographs. She knew how dowels reacted on bone. She also testified she had extensive training in trajectory. So if we assume, and for the sake of argument, we assume that this was a preserved issue, we're looking at whether or not the trial court abused its discretion in making a determination that she could give her opinion.
Wasn't there a difference between trajectory and ballistics?
Yes, Your Honor. However, as it spoke to the specific opinion that she was giving here, really what she was testifying to was her experience based as a forensic pathologist. And what keys us into where the trial court actually exercised good discretion was the reason that the medical examiner went back out and re-investigated this issue. After the first trial, before the first trial, she was giving her opinion based on the presumption that Jordan had been seated at the time that he was shot. At the first trial, she was cross-examined on the fact that he may have been standing at the time. So, and this is right at the beginning of her deposition, she says that before I could ever go back and testify for our office and the completeness, we needed to determine whether or not the impressions that I had operated under were consistent with the vehicle and consistent with the new possibility that was raised at trial. So what she was saying is, I can't give my expert opinion as a forensic pathologist unless I know where he was standing in the position of everything. So the limited purposes that she was testifying for was not for this accident reconstruction that Dr. Knox, who was the defendant's expert in the second trial, was testifying to as to how fast these shots were fired and which way they came in, as far as where the appellant's car would be positioned and where appellant was and the heights of everything. What she was saying is, I have to determine where his body is in order to be able to give my proper opinion. I went back out, I placed dowels in the car, and I determined that he must have been seated and that door must have been shut. And she was basing that opinion on her expertise in forensic pathology, bolstered by this additional qualifications that were ferreted out through the deposition.
Counsel, the appellant relies on the 4th District opinion in Matic versus White in support of his position that Dr. Simmons testified outside her field of expertise. Can you distinguish the Matic case from this case?
Your Honor, what the real big factor is was that this was within her expertise area. And it won't even make a difference as far, this is where we get into the whole preservation issue of this case and whether or not what was actually objected to was what we're arguing on appeal. Her expertise was established by that deposition testimony. And what came up at trial, and this regards the textbooks and the use of texts within her analysis, at trial, and this was not in the deposition, this was not a question asked at the deposition as far as I could find, it was certainly not testified to. She never testified that she had relied on textbooks. Then at the trial, she gives this additional expertise, saying that I also relied on text. So here, and the big difference is that she wasn't solely relying on textbooks. She was also coupling that expertise with textbooks. Now, after she gives that additional expertise, there's no objection raised. And this ties back into the preservation issue because really the motion in limine is only definitive if the circumstances are the same for the motion in limine hearing and the trial. And that comes from the decision of Powell v. State out of the 5th. And there, the big difference is that something changed between the motion in limine hearing and the trial. So although they re-raised their objection prior to this testimony, what appellant does is voir dire's the witness anyways and says, well, let's see if you really have these qualifications. And during that voir dire at the second trial, she says, oh, I also relied on these specific texts. So when the trial court made its initial finding that she had these qualifications, it said this was solely based on her experience. Now at trial, we have experience plus additional text. So one, appellant should have then objected to preserve this issue, saying, wait, these are additional concerns, and I still don't think this meets the standard. But even still, we now have additional evidence that she's not relying solely on text, as has been argued in appeal. She's relying on her experience, her training, and these texts to be able to give an expert opinion. And that opinion is still based on her foundation as a forensic pathologist, that she could not testify as to these wounds unless she knew whether or not he was seated or standing. And I really love one of the things she says, and this really bolsters why I think this was not an abuse of discretion if this was preserved. And this is on volume 41, 2090 of the record. We are forensic pathologists, and if something doesn't make sense to us, we raise a red flag and we say we need more information. That's just par for the course. That's what she's testifying to. She said something raised a red flag in my opinion. So I'm going to go back and I'm going to relook at this. And the trial court didn't abuse its discretion. This is not some sort of arbitrary or fanciful decision. It's saying, look, for the limited purposes of determining where Jordan was, whether he was seated and whether the door was open or closed, she was able to go back and give that opinion. So as it relates to the first issue, the state presented inconsistent evidence of appellant's self-defense claim. And on this issue, the trial court didn't abuse its discretion in limiting or allowing her to give her expert opinion as to the position of Jordan's body at the time of the shooting or the position of the door, if this issue was even preserved, because it was not re-objected to after she gave additional qualifications at trial. For these reasons, we ask that you affirm the decision below. Thank you.
Thank you, counsel.
All right. I think Judge Winokur, you seized on the comment that it's absolutely not the law that if there was no shotgun, there's no self-defense, and that's absolutely what our argument is under the Diaz and Rivera case. Is that it was all right for Mr. Dunn to be mistaken about the presence of a firearm. Again, the jury instruction says that the danger need not have been actual, that the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could only be avoided through self-defense. And that based upon appearances, the defendant must have actually believed that the danger or emergency was real. So now, in Dunn and Rivera, both those cases reversed after someone shot, fired in self-defense, killed someone, said, I saw a gun, and then they said, ooh, there's no gun. We can't find a gun. So but both those, and that's why they're cited.
But Diaz, there wasn't a witness to say that that Mr. Diaz's belief was not reasonable. Here, there are a number of witnesses who create a factual issue, I believe, that Mr. Dunn's belief that there was a shotgun in the Durango was not a reasonable belief. So he says, I've got a reasonable belief. I thought there was a barrel of a gun. Other witnesses say no gun, so no reasonable belief. Isn't that a fact question then?
I don't think so, Your Honor. In Diaz, as the state noted, the fact was that the decedent in that case was reaching into a pocket. Here we have something more than that. We have to look at Mr. Dunn's perspective. He was in a driver's seat looking back over his left shoulder at someone in a right side passenger seat. And there was an object in his hand coupled with a death threat, and either getting out of the vehicle while the death threat happens, or trying to get out of the vehicle. So we have a lot more aggression and something that would put you in reasonable fear than walking across a room and maybe touching your pocket, and a death threat in Diaz. Same thing in Rivera. There was a chase with a vehicle, and then the person got out of the vehicle, but there was no gun. Here, there's something in the hand. So that's one factor that's further in Mr. Dunn's favor. He could have been mistaken, but all he had to show was that he actually believed that the danger was real. And that it's
a reasonable belief.
Well, there was something in his hand coupled with a death threat and an attempt to approach. I mean, that's the prima facie case of self-defense that wasn't rebutted. Now, in regard to the "you're not going to talk to me" comment, which was a slightly different variation on the "are you talking to me" that struck people as more aggressive. You're not going to talk to me like that. That comment is a little different than what Mr. Brunson and Mr. Thompson and Mr. Dunn all agree he said. Frankly, I think the "are you talking to me" is what happened, but the "you're not going to talk to me" is there in the record. It could be sufficient evidence if it was sufficient to rebut a claim of self-defense. However, when we have an unrebutted claim of a death threat, I don't think anything about that alternative phrasing, "you're not going to talk to me like that." Talk to me like that means you're not going to threaten me with death. This is prompting me to self-defense. That's not inconsistent. It's more aggressive. It's a more aggressive form of self-defense. I'm going to stop you from killing me. I'm not going to let you threaten me with death. And then try and get out of your vehicle with something in your hand that I think is a gun. But it doesn't rebut. It's not inconsistent with self-defense. I think a lot of people get angry when they're defending themselves against a perceived death threat, whether they're correct about whether the assailant has a gun or not. People get angry when they're using self-defense. Now, in regard to, I do want to briefly touch on the medical examiner's testimony. I see I'm almost out of time, but the state noted that they were not tendering her as an expert in crime scene construction, and Ms. Simons, or Dr. Simons, tried to say that she was just giving common sense testimony. I see I'm out of time, so I won't.
You may wrap up, counsel. You may wrap up.
Okay. The coroner, we have to remember that she wasn't merely just trying to explain the path of these bullets from the Jetta, Mr. Dunn's car, through the door to the body, which would be colorably medical. She admitted candidly at page 2051 that she couldn't tell which bullet created, which hole in the door corresponded to which wound on the decedent's body. So she's really going out with dowels, taking tables to represent the Durango, taking dummies and positioning them in ways that are completely inconsistent with coroner testimony about injuries to the decedent's body, and taking that and making statements about what doors do when they're open, they automatically close, which of course they don't if you're standing next to them. My door doesn't automatically close on my car when I let it go, it stays. She's talking about the position of the body, not just the injuries and the cause of death. She was absolutely doing accident scene construction. She didn't know where the Jetta was. She had never measured the heights of the Durango or the Jetta. She never visited the parking lot the way the real accident reconstruction witness did. And he testified in the second trial that you absolutely cannot do any kind of accident scene construction extrapolating backward from wounds to a body. There shouldn't have been any war of experts about whether Mr. Davis was getting back into the vehicle partway in and out, partway out. There shouldn't have been a need to rebut that. But because the coroner, the medical examiner, was allowed to say where Mr. Davis was doing, or where he was, what he was doing, and whether his car door was open, which are physics opinions, not medical opinions, the jury was, in a way that was unwarranted by her expertise or common sense, whichever she wants to say it was. She said it both ways.
Thank you, counsel.
Thank you, Your Honor.
Thank you both for your respective thorough and complete oral arguments. We stand adjourned.
All rise.